Hello students, today we will be discussing the topic of implementation of Manual Scavenging Act 2013, need for reforms. Introduction of the topic. Manual scavenging, a dehumanizing practice, though denied of often non-existence, is still prevailing in various parts of India. Those engaged in this occupation often belongs to Dalit of Dalits in major proportion and also other scheduled caste community to a minimum extent. Specifically, the scheduled caste community who are stratified in the lowest ladder of the social order are frequently dragged on to be performed manual scavenging. They are not in a state to overcome the social tyranny of the conventionally forced employment on them. Thus, for the purpose of survival, they are forced into with no other alternative left out than to engage in manual scavenging. The people who remove human excreta have been addressed as manual scavengers in the country by the existing literature, and they largely belong to the Dalit community. In some place, low caste Muslim also pursue the work and rank the lowest in the hierarchical structure. The scavenger community in India is highly heterogeneous and subsumed under layers of subcaste. The census defines manual scavenger who cleans a dry latrine or carries human waste to dispose it of. The definition, like much of the discourse, is centered upon dry latrine cleaning. Definition of manual scavenging. As per Encyclopedia, the Prohibition of Employment as Manual Scavenger and the Rehabilitation Act 2013. Manual scavenger means a person engaged or employed at the commencement of this act or at any time thereafter by an individual or a local authority or an agency or a contractor for manually cleaning, carrying, disposing of or otherwise handling in any manner human excreta in an insanitary latrine or in an open drain or pit into which the human excreta for insanitary latrines is disposed of, or on a railway track or in such other spaces or premises as the central government or state government may notify, before the excreta fully decomposes in such manner as may be prescribed. A person engaged or employed to clean excreta with the help of such devices and using such protective gear as the central government may notify in this behalf shall not be deemed to be a manual scavenger. The Asian Human Rights Commission defines manual scavenging in the following terms. Manual scavenging in India is officially defined as lifting and removal of human excreta manually at private homes and toilets maintained by municipal authorities. The practice consists of gathering human excreta from individual or community dry latrines with bare hands, brooms or metal scrapers into woven basket or baskets. The scavenger then carry on their heads, shoulder or against their hips and in wheelbarrow if they can afford it into dumping sites or water bodies. Apart from this, many scavengers are similarly employed to collect, carry, dispose excreta from sewers, septic tanks, drain and railway tracks. Occupational health hazards of manual scavenger. An estimated 1.2 million scavengers in the country are involved in sanitation of our surroundings. The working condition of these sanitary workers have remained virtually unchanged for over a century. Apart from the social atrocities that these workers face, they are exposed to certain health problems by virtue of their occupation. These health hazards include exposure to harmful gases such as methane and hydrogen sulfide, cardiovascular degeneration, musculoskeletal disorders like skin problem, respiratory system problems and altered pulmonary function parameters. Constitutional provisions. Since manual scavengers belong to backward section of society, they are entitled to some special rights apart from rights under Indian Constitution. Some of the important and relevant constitutional provisions are as follows. Article 14, equality before law, right to equality. Article 16 clause 2, equality of opportunity in the matter of public employment. Article 17, abolition of untouchability. Article 19 clause 1 subclause A, right to practice any profession or carry on any occupation, trade or business. Article 21, protection of life and personal liberty. Article 23, prohibition of traffic in human being and forced labor. Article 41, right to work, to education and public assistance in certain circumstances. Article 42, just and human conditions of work. Article 46 Promotion of educational and economic interest of scheduled caste, scheduled tribe and other weaker sections. Article 47 Duty of the state to raise the level of nutrition and the standard of living and to improve public health, and Article 338 of the Constitution, Constitution of National Commission for Scheduled Caste. Legislative framework. Apart from plethora of constitutional provisions, the legislature has enacted several enactments for the upliftment of scheduled caste, including manual scavengers. Some of the major enactments are as follows. The Protection of Civil Rights Act 1955. Initially, the Untouchability Offences Act 1955 had been enacted to abolish the practice of untouchability and social disability arising out of it against the members of scheduled caste. It was amended in 1977 and is known as Protection of Civil Rights Act 1955. Under the revised act, the practice of untouchability was made both cognizable and non-compoundable offence, and stricter punishment was provided for the offenders. The Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989. The Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act of 1989 came into force on January 31, 1990. The Act inter alia specifies some type of offences as atrocities, provides for imposition of stricter penalties for the guilty and setting up of special courts for speedy trial of such cases. The main objective of the Act is to prevent the commission of offences of atrocities against the member of scheduled caste and scheduled tribes, and to provide for special courts for the trial of such offences and for the relief and rehabilitation of the victim of such offences and for matter connected therewith or incidental thereto. The Act was further strengthened in relation to manual scavengers by recent amendments. The Act, which was notified by central government on January 1, 2016, make it a punishable offence to employ, permit or make any person belonging to SC/ST community to do manual scavenging. The contravention of the said provision attracts an imprisonment for a term not less than 6 months and may exceed to 5 years and fine. Employment of manual scavengers and construction of dry latrine Prohibition Act 1993. The employment of manual scavengers and construction of dry latrine Prohibition Act 1993, herein referred as EMSC DL Act 1993, provides for prohibition of employment of manual scavenger as well as construction or continuance of dry latrines, and for regulation of construction and maintenance of water sealed latrines and matter connected therewith. It was replaced by PEMSR Act 2013. National Commission for Safai Karmacharis Act 1993. The Act established the National Commission for Safai Karmacharis to study, evaluate and monitor the implementation of various schemes for Safai Karmacharis as an autonomous organization and also to redress their grievances. The Act is a welfare legislation enacted for the welfare of persons engaged in cleaning and plumbing jobs in various state departments. Section 31 of the PEMSR Act bestows statutory responsibility on the National Commission for Safai Karmacharis to monitor the implementation, inquire into the contravention and non-implementation of the PEMSR Act 2014. National Commission for Scheduled Caste. The Commission is constituted with the mandate to safeguard the interests of scheduled caste in India. Article 338 Clause 5 of the Constitution of India lays down certain duties of the NCSC, which are: Number 1. To investigate and monitor all matters relating to safeguard provided for scheduled caste and evaluate the working of such safeguards. Number 2. To inquire into specific complaints with respect to the deprivation of right and safeguards of the scheduled caste. To participate and advise on the planning process of socio-economic development of the scheduled caste and to evaluate the progress of their development. Number 3. To make recommendation as to measures that should be taken by the Union or any state for the effective implementation of those safeguards and other measures for the protection, welfare and socio-economic development of the scheduled caste. Number 4. To discharge such other functions in relation to the protection, welfare and development and advancement of the scheduled caste. Number 5. To make in such a report recommendation as to the measures that should be taken by the Union or any state for those implementation of those safeguards and other measures for the protection, welfare and socio-economic development of scheduled caste. Prohibition of Employment as Manual Scavengers and their Rehabilitation Act 2013. Salient features of the Act. The Act prohibits the employment of manual scavengers, the manual cleaning of sewers and septic tank without protective equipments, and the construction of insanitary latrines. Its main objectives are prohibition of employment as manual scavengers, rehabilitation of manual scavengers. The Act recognizes the link between the manual scavengers and weaker section of the society. It therefore views manual scavenging as being violative of their right to dignity. Under the Act, each local authority, cantonment board and railway authority is responsible for surveying insanitary latrines within its jurisdiction. They shall also construct a number of sanitary community latrines. Each occupier of insanitary latrines shall be responsible for converting or demolishing the latrine at its own cost. If he fail to do so, the local authority shall convert the latrine and recover the cost from him. The district magistrate and the local authority shall be implementing authorities. Offences under the Act shall be cognizable and non-bailable and may be tried summarily. It provides for detailed vigilance mechanism and monitoring committee at district, state and central level. The Act specifically provides for carrying out surveys for identifying persons employed as manual scavengers. Judicial intervention in manual scavenging. Judiciary has always played an active role in strengthening the cause of socio-economic welfare by translating several directive principles into enforceable right for the upliftment of poor and weaker section of society. A liberal interpretation of Article 21 of the Constitution has created numerous rights and has given new direction to social welfare jurisprudence in India. With regard to judicial response towards manual scavengers, recently courts have adopted a stern attitude towards the manual scavenging and pulled up the state authorities for failing to as an inhuman, degrading and undignified profession. The Supreme Court observed that PEMSR Act 2013 and EMSCDL Act 1993 neither dilutes constitutional mandate of Article 17 of the Constitution, nor does it condone inaction on part of union and state government. The Supreme Court held that the PEMSR Act 2013 expressly acknowledges Article 17 and 21 of the Constitution as the rights of the persons engaged in sewage cleaning and cleaning tanks as well as persons cleaning human excretion on railway track. Satha Swam CJ said that official statistics of Ministry of Social Justice and Empowerment for year 2022 and 23 put the figure of identified manual scavenger at 676,009. Of these, over 95% are Dalit compelled to undertake this denigrating task. The Supreme Court also referred to several international covenants and instruments to which India is a signatory that seeks to guarantee a dignified human life in respect of his profession and other walks of life. Example, Universal Declaration of Human Rights, Convention on Elimination of Racial Discrimination and the Convention of Elimination of all form of discrimination against women. Supreme Court laid down following proposition with regard to rehabilitation of manual scavenger. If the practice of manual scavenging has to be brought to a close and also to prevent further generation from the inhuman practice of manual scavenging, rehabilitation of manual scavenger will need to include: Number 1. Sewer death. Entering sewer lines without safety gears should be made a crime even in emergency situation. For each such death, compensation of rupees 10 lakh should be given to the family of the deceased. Number 2. Railways should take time-bound strategy to end manual scavenging on the tracks. Number 3. Persons released from manual scavenging should not have to cross hurdles to receive what is their legitimate due under the law. Number 4. Provides support for dignified livelihood to Safai Karamchari women in accordance with their choice of livelihood scheme. Number 5. Identify the families of all persons who have died in sewerage work since 1993 and award compensation of rupees 10 lakh for each such death to the family members depending on them. Number 6. Rehabilitation must be based on the principle of justice and transformation. Supreme Court stressed on the rehabilitation of manual scavenger in accordance with Part 4 of PEMSR Act 2013. The Supreme Court directed the state government and union territories to fully implement various provisions of PMSR Act 2013 and take appropriate action for non-implementation as well as violation of provisions contained in PMSR Act 2013. In case of Delhi Jal Board versus National Campaign for Dignity and Right of Worker Sewerage and Allied Worker, in the present case the Supreme Court passed a landmark judgment identifying and highlighting the apathy and plight of the disadvantaged section of the society, particularly the scavengers and sewage workers who risk their life by going down the drainage without any safety equipment and security and have been deprived of fundamental right to equality, life and liberty for last more than 6 decades. The Supreme Court referred to a report and stated that the workers are suffering from high mortality due to exposure at workplace. 33 workers had died in last 2 years due to accident while working on the blocked sewer lines. 59% of the workers enter underground sewer manholes more than 10 times a month and half of them have to work for more than 8 hours a day. 41 workers have reported syncope and other 24 reported temporary loss of consciousness. A little over 1/3 of the workers had been immunized against tetanus while none of them had been vaccinated against hepatitis B. Approximately 46% of workers across all age groups were found to be underweight according to body mass index calculation. All daily wages were getting a wage of approximately 2950 rupees per month without any other benefit irrespective of service period. On the issue of judicial activism and overreach by the court as contended by Delhi Jal Board, the Supreme Court observed that whenever one of the 3 constituents of the state, that is judiciary, has issued directions for ensuring that right to equality, life and liberty no longer remains illusory for those who suffer from the handicaps of poverty, illiteracy and ignorance, and directions are given for implementation of the law enacted by legislature for the benefit of the have-nots, a theoretical debate is started by raising the buoy of judicial activism or judicial overreach, and the order issued for the benefit of weaker section of society are invariably subjected to challenge in the higher court. In large number of cases, the sole object of this litigative exercise is to tire out those who generally espouse the cause of the weak and poor. The Supreme Court also criticized the government and the state apparatus on being insensitive to the safety and well-being of those who are on account of sheer poverty compelled to work under most unfavorable conditions and regularly face the threat of being deprived of their life. Supreme Court also snubbed the elitist mindset of the wealthy class with regard to public interest litigation, pro bono litigation. The Supreme Court not only directed to pay higher compensation to the families of the deceased, but also directed the civics body to ensure immediate compliance of directions and orders passed by Delhi High Court for ensuring safety and security of the sewage workers. Various Supreme Court judgments have under the right to life upheld the right to employees' health. Consumer Education and Research Center and others versus Union of India. The verdict given by Supreme Court in this case is one such instance. It says, we hold that right to health, medical aid to protect the health and vigor to a worker while in service or post-retirement is a fundamental right under Article 21, read with Article 39E, 41, 43, 48A and all related articles and fundamental human rights to make life of the workman meaningful and purposeful with dignity of the person. However, according to a report brought out by Center of Education and Communication on Health and Safety Workers of Delhi, fatal sewer accidents are frequent for sewage workers, manual scavengers. The highest ranked known cause of such death is respiratory disease triggered through chronic illness. Apart from it, there are several other infections like gastroenteritis, intestine, parasitic infection and fever which are prevented among the sewage worker. Most of the workers do not complete the entire service period of 60 years of age. They often cross the exposure limit where entry to sewer manhole is made 10 times a month, that too on the basis of 8 hours a day. On maximum occasion, no formal training or information is disseminated by employers about the hazardous work. Added to it, dearth of protective gears is another problem which intensifies the assurance for death. An NGO in Ahmedabad named Manav Garima, led by Balmiki activist Purushottam Vaghela had documented the death of 145 manhole workers in 7 years in the municipality of Surat and Ahmedabad. In Mumbai, according to data obtained under the RTI Act, 2.039 Safai Karmcharis died between 1996 and 2006 in 14 of the city's 24 civic ward. Similarly, in a reply to Right to Information query, the PMC Health Department has admitted that 44 employees had died from October 2005 to March 2006, 144 from April 2006 to March 2007, and 37 from April 2007 to September 2007. Government's apathy to collect more dust to the plight of the sewage workers. Various schemes which are implemented by government at state and central level differed in the level of commitments. Besides lack of coordination between institutions in governmental hierarchy often result in disorienting or fading the objective before reaching its goal. The national scheme of 1992 on sewage worker reflects such picture. The scheme was launched for identification, training and rehabilitation of Safai Karmcharis. The progress has not been altogether satisfactory. As a result, it has benefited only a handful of Safai Karmcharis and their dependents. One of the reasons for unsatisfactory progress of this scheme appears to be inadequate attention paid to it by the state governments and concerned agencies. Even those working for urban municipalities are paid Rs 30 to 40 a day, and those working privately are paid Rs 5 per month for each house they clean. Even those working for municipalities rarely get paid and are often little health benefits or a job that entails many health hazards. In cities, scavengers are actually lowered into filthy gutters. In order to unclog them, they are fully immersed in human waste without protective gear. This is done despite the legal ban on manual scavenging as mentioned in the Employment of Manual Scavenger and Construction of Dry Latrine Prohibition Act 1993. The Act punishes the employment of scavengers or the construction of dry latrines with imprisonment for up to 1 year and for a fine as high as Rs 2000. Breach of this act is one way is a sheer violation of human rights. Several studies reveal that workers from this sector are severely prone to low level of health securities. This crisis and risk situations are directly proportional to income generated by these workers. Presence of this attitude is more pronounced in Report of Social Security for Unorganized Worker published by National Commission for Enterprises in Unorganized Sector in May 2006. The case of removal of Life Insurance Corporation policy for Pune sewage worker of late in October 2007 draws attention to such analogy. For a sewage worker who is also from the unorganized sector, the situation is more grim compared to other. Upholding the dignity of the individual as enshrined in the preamble of Indian Constitution, Prohibition of Employment as Manual Scavenger and the Rehabilitation Act 2013 aims to provide for the prohibition of employment as manual scavenger, rehabilitation of manual scavenger and their families and matter connected therewith or incidental thereto. Therein the Act states that hazardous cleaning by an employee without employer fulfilling his obligation to provide protective as may be prescribed or provided in any other law for time being in force or rules made thereunder, dating back to employment of manual scavengers and construction of Dry Latrine Prohibition Act 1993, which states, no person, local authority or any agency shall after the date of commencement of this Act engage or employ directly or indirectly a manual scavenger, and every person so engaged or employed shall stand discharged immediately from any obligation expressed or implied to do manual scavenging. In spite of all the raising awareness case like the death of 3 men in sewage manhole at Dharampuri district in Tamil Nadu and the death of 3 men at Indira Gandhi National Center for Arts in central Delhi shows the continuance of this profession with negligence. Concluding the topic, it can be concluded that the dehumanizing practice of manual scavenging is officially banned since decades in India under the Employment of Manual Scavenger and Construction of Dry Latrine Prohibition Act 1993, which makes the provisions for abolishment of this practice and for identification and rehabilitation of manual scavenger, and under the more recent the Prohibition of Employment as Manual Scavenger and the Rehabilitation Act 2013, which is revised and broadened the Act of 1993 and established more stricter punishment. The 1993 Act outlines prohibition of and maintenance of dry latrines and employment of manual scavengers. However, as reflected by figure of Census 2011, there are still 26 lakh insanitary latrines in the country where human excreta is either being deposited into open drains or removed manually, and manual scavenger continues to clean these dry latrines in spite of the bans imposed, barred legal and with periodic appointment of various committees and commissions by the government to look into the plight of the manual scavenging community. Manual scavenging continues unabated across different states of India. Thank you and good day.